Yeah, so Grażyna Baranowska is an assistant professor at the Poznan Human Rights Center, Institute of Law Studies of the Polish Academy of Sciences, and soon will be based at the Hertie School in Berlin for her Marie Skłodowska-Curie Action Project on missing migrants. Her book, Enforced Disappearances in Europe, is, I think, hot off the press, published last month. So please, everyone, except of the speaker, mute yourself. Grażyna, the floor is yours.
Thank you, Nina, for the kind introduction. Let me just share my screen. Okay, so that should work now. Okay, just do you see everything? Is everything good? Okay, perfect. So let me just, I like to time myself too. So that was a really inspiring first two sessions, and thank you for the speakers and the discussions. And I see there's a lot of things that I've thought about that they're absolutely not answering the questions raised in the previous sessions, but they really speak to them. So it really shows that the workshop is put together with the same questions and similar approaches. So my presentation today will connect two projects, one that I have finished and one that I'm starting. So as has been nicely presented by Nina, my book was just published a couple of days ago, so it's the first time I'm showing the cover. That's very exciting. And it concerns right of families of disappeared persons, how international bodies address the needs of families of disappeared persons in Europe. And I'm connecting that to a project that I'm starting soon at the Hertie School of Governance, which is a Marie Curie project on missing migrants. So just to show you how the part on substantiating claims kind of fits into the book and the broader picture on enforced disappearances. So there's a part in the book on the main part of the book are judicial mechanisms. There's also a part on non-judicial mechanisms. And the one on judicial mechanisms, the biggest part concerns the European Court of Human Rights. And then there's a chapter on the UN Human Rights Committee and on post-Yugoslav countries. And in the context of the European Convention, it's particularly interesting that two of the international bodies actually deal with the European Convention on Human Rights and the case law of the European Court of Human Rights. And in some of them, there are even former judges of the European Court of Human Rights. So it's a way kind of to see how a different body taking the same document and the same case law is reaching in different perspectives with regard to some issues. And the conceptual framework that I proposed in the book with regard to the judicial bodies is first I looked what the challenges are to admissibility due to temporal issues. And with regard to secret migrant detention, I do not believe that that would be really a challenge because of the specificities of those potential applications. With regard to substantiating claims that an enforced disappearance occurred, I believe that they were really similar, and there are some very important similarities that can be drawn with the existing case law and potential applications. The third thing I looked at was recognizing families of disappeared persons as victim under Article 3. And actually looking at the existing case law of the European Court of Human Rights, I do not believe that families of migrants that were victims of secret detention, at least the vast majority of them, that they would be recognized as a victim under Article 3 because of the length of the disappearance. And the last aspect which I looked at, which is not really relevant for today's presentations, are measures of reparation. And I looked at how the judgments are executed. So with regard to the European Court of Human Rights, mostly at the Committee of Ministers, the process that's going on with regard to Russia and Turkey predominantly. So my main question today is how to substantiate migrant detention at the European Court of Human Rights when states are denying the fact. So the situation that we are having is a migrant says, I was detained by a state, most usually at the border crossing, and the state says, well, it did not happen. So nothing else, it just did not happen. And this would be kind of the situation where we start off with. I will shortly start today's presentation on saying what I understand as secret migrant detention, very briefly show how enforced disappearances have been dealt by the European Court of Human Rights, and then apply two elements to secret migrant detention, how facts have been established, and a reversal of burden of proof. So that speaks to a lot of discussions that have been going on today. The last slide will be on the practice of disappearance, and I was really interested in what has been said already with regard to that. It speaks to the discussions. So those would be probably the pictures that come into our mind when we hear secret migrant detention in Council of Europe states. So it's detention that takes place at the border, often at unofficial sites, vans, boats, forests. Is keeping someone in the forest, a deprivation of liberty, and so on. So secret migrant detention is not a defined term. And when I use it today, what I mean is there has to be at least a deprivation of liberty by state authorities and a refusal to acknowledge this fact or disclose the fate of the disappeared person. So that's the definition of enforced disappearances. And I apply that to migrants in today's presentation. And with regard to secret migrant detention, as it takes place, raised by NGOs at the borders of the Council mostly at the borders of the EU. There are some additional challenges that make it different from the traditional enforced disappearance cases. So the first would be the length of the deprivation of liberty. And in most cases, we are talking about an alleged a couple of hours or mostly a couple of days. So for example, in a pending case against Croatia, it was several hours that the Syrian men were deprived of their liberty. And that's different to the more traditional enforced disappearance cases that have been adjudicated. Then the second issue, it's in most cases, those are unofficial sites. So it's not the prison, not the police station, although sometimes it is, but it's often vans, cars, boats, some unofficial places where people should not be deprived of their liberty at all. Another element is that no one is asking for the migrants. And this is important with regard to evidence and enforced disappearances, because it's the first evidence that the family usually brings to the international court. So a person is deprived of his or her liberty, and then the next day or a couple of days later, the family goes to police officer, to the prosecutor, to a prison, and asks for their loved ones. And the refusal, the information that they're not getting, is the first evidence that then bring they forward to the European Court of Human Rights. And in most secret migrant detention cases, this would not be available, as a lot of the migrants are unrecognized or are traveling by themselves or are afraid to get in touch with police officers and just ask for their friends or loved ones. So this is something that would not be in the evidence as in the traditional enforced disappearance cases. And which is actually not a challenge, but it's one thing that is very different from the traditional enforced disappearance cases, is that in most cases, we will be talking about the reappearance of the person. So the person is deprived of his or her liberty and then appears again, often in another country. Notwithstanding those challenges and the specificity, if a detention reaches all the thresholds I mentioned in the last slide, it is an enforced disappearance, irrespectively of the duration where it takes place. And this is clear looking at enforced disappearances. And I talked a bit more about that in an analysis published by the German Institute for Human Rights, so which closely deals with enforced disappearances, and not the European Court of Human Rights, but kind of broader the context. There are over 200 judgments on enforced disappearances, and it includes an interstate judgment. So it's really a vast case lot. Enforced disappearances have not been defined by the European Court of Human Rights, but the case law was developed with regard to persons that disappeared during the deprivation of liberty. So a regular case would be someone that did not appear after he or she was deprived of her or his liberty. And the one exception are extraordinary rendition cases, so the cases of secret detention by the CIA and the cooperation of European states. And here in El Masri versus former Yugoslavian Republic of Macedonia, the court stated famously that the detention and abduction amounted to an enforced disappearance as defined in international law. And looking against the background of enforced disappearance cases, it's a really strong statement because the court has never stated that in other cases. So when deciding regular enforced disappearance stated, the court never stated it amounts to enforced disappearance as defined in international law. And this is one of the examples of the few reappearance cases that we have in the case law. So now moving on to the evidence and establishment of facts, as I said, I wanted to start with that element. The court, when developing the case law, it pointed to the fact that those are exceptional cases. So the exceptionality of those cases arises from the fact that there is a strong alleged violation of Article 2 and/or 3, and that there's a significant difference between the parties' version of events with respect to the basic underlying fact. And that makes them exceptional and makes it possible to kind of approach the establishment of facts a bit different than other cases. In the early enforced disappearance cases, there were very big and important fact-finding missions. So witnesses were talked with, the applicants were talked with, documents were looked at in the country, that were Turkish cases in Turkey, authorities were summoned, many officials did not show up, but it was tried kind of to talk to the officials that were responsible for that. And with time that's changed, of course, and the court moved to looking more at procedural obligations. So then there was, in most cases, there's a procedural violation of Article 2, often more than substantive violation. There's also the court looked at the rules of the burden of proof, which I will talk kind of in the second part. And what I think is really interesting is the broadening on the perspective of what is life-threatening. So in the first cases, the applicants would have to prove that their loved one was sought for by the authorities. So he was a journalist or a politician that was really wanted by the authorities. And because of that, his detention was life-threatening. With time, the court moved to a perspective where it said, well, this is not only if somebody is wanted, but also the very secret detention in southeastern Turkey or in Chechnya is life-threatening. There's still room for improvement, I believe, because treaty bodies and other bodies have accepted that every secret detention is actually life-threatening. But this is really a development that helps kind of to build a case and to bring evidence forward. So what the court had stated is that when the applicant is generally in possessing of little evidence, satisfactory proof may result from the coexistence of sufficiently strong, clear and concordant interference or of similar unrebutted presumption of facts. And we're talking about the case where almost all of the evidence is in the hands of the state, and the state is denying the very facts that were happening. So the court accepted a lot of different evidence, so unofficial photocopies of documents, film clips of events, even of not very high quality, circumstantial evidence, and it was really flexible in accepting and letting applicants apply things. So now looking at two examples of secret migrant detention that did not reach the European Court of Human Rights, but kind of to show what kind of evidence could be brought to the European Court of Human Rights. So the first case I wanted to mention is a communication brought to the UN Human Rights Committee last year. It concerns a Syrian man that he was granted refugee status in Germany, and then he traveled to Greece to look for his missing brother. There he was apprehended by Greece police and expelled to Turkey. And then he tried to cross the border for a number of times. Then eventually he succeeded, and he was able after a long time to restate his status in Germany. So the applicants argue that this concerned an enforced disappearance. And for me, what is important is the evidence presented in the case. The applicants, the lawyers cooperated with forensic architecture, and they set up the evidence based on three elements. So first, the situated testimony, which is a methodology to speak with the person that went through this violation, fieldwork in Greece, as well as remote sensing analysis, including satellite imagery. And looking at the case law with regard to enforced disappearances of the European Court of Human Rights, I would believe that this form of a reconstruction of events would be also accepted at the European Court of Human Rights. And the second example is an example that was, as far as I know, has not reached any international bodies, but it gives an example of another form of evidence that could be used with regard to migrant detention. Here you see a picture of Aisha Erdogan. She's a Turkish teacher who crossed in May 2019 the border to Greece to ask for asylum, and she was allegedly apprehended by Greece police. And as her brother was already in Greece, she contacted him via WhatsApp, and he, as they exchanged WhatsApp messages, he was able, through a satellite information, to find where she was based, and this is proof that she was at a police station in Greece and at the Greece part of the border. So this could also be evidence. I have not seen a case that such evidence was put forward, but I believe that this could also be kind of show that she was in fact deprived of her liberty. Now moving to the reversal of the burden of proof, and here again the court stated that the strong presumption of facts arose because, well, highlighting also the alleged violation of Article 2 and 3, and when the events in issue lie within the exclusive knowledge of the authorities. So these are kind of the two elements that are highly relevant in those cases for the reversal of the burden of proof. And kind of as a sideline, because we will hear more about that, I assume in the second presentation, there's the lack of cooperation by the state with the European Court of Human Rights. And if that appears without the satisfactory explanation, and this is judged by the court itself, in itself does not constitute a ground for automatically accepting the truth of the applicant's allegation, but it may give rise to drawing inference as to well-foundedness of the applicant's allegation. So this is an element that is also taken into consideration by the court. So the court stated that in particular circumstances, the burden of proof may rest on the accused state, and then further developed it that when the necessary evidence is in the hand of the state, applicants would still have to make a prima facie case, and that was clearly stated in Todge versus Strickland in 2005. And that was then developed 1 year later in Baranowska versus Russia. The court stated, well, this is clearly a prima facie case with regard to enforced disappearances. However, the applicants had really strong evidence in the case concerning video clips of the person being deprived of his liberty. So subsequently, the court accepted much weaker evidence to reverse the burden of proof, and examples that could be relevant and secret migrant detention case, in my opinion, would be testimonies of eyewitnesses of the disappearances. So it's a neighbor that saw somebody being deprived of her liberty, that would then, in particular circumstances, serve to reverse the burden of proof. A testimony of a person that was detained with a disappeared, and an example in a kind of the border perspective that might be most interesting was the fact that a group of men moved freely despite roadblocks, checkpoints, and curfews. So the court stated, well, if they were able to move, then that means they were supported by the state, and the disappearance that the state needs to argue what happened to that person, needs to find the reason why the person disappeared. So kind of this is exactly the situation that we could call a border situation. So if there is a group of men or women moving freely at the border region and then somebody is disappearing, this could be connected using per analogy the case law on enforced disappearances. So now moving to the practice of disappearances, this has been raised and criticized many times in the context of enforced disappearances because the Inter-American Court of Human Rights accepted such a concept in Velázquez-Rodriguez versus Honduras, where it stated that there was a practice of disappearances in Honduras, and if you could connect your disappearance with the practice, then the burden of proof would shift. So it's not that every disappearance would, if you stay, like speaking to the discussion that we had on the panel this morning, it's not that every disappearance would then be able to lead to the shift of the burden of proof, but only those disappearances that you can connect with this specific practice. So this has never been accepted by the European Court of Human Rights. It has been argued many times by applicants and lawyers from the very first cases concerning Turkey, and the numbers are higher than in Honduras, so it would be kind of enough per analogy to make such a practice of disappearances. In 2012, the court confirmed that there was a practice of disappearances using those words, but it did not connect this concept to the shifting of the burden of proof, so it does not have the same meaning. And also with regard to Czechia, persons were trying to kind of get out this concept of practice of disappearance, but unsuccessfully. It was called that there was a phenomenon of disappearances that was well known, so this might be kind of the same understanding, but also this did not lead to the shifting of the burden of proof. And so concluding, substantiating claims has been really developed with regard to enforced disappearances at the European Court of Human Rights, and compared to the other courts that I have looked at, there's really strong and good for the applicants development at the European Court of Human Rights. And the court itself has highlighted that this is because of the alleged violations of Article 2 and 3. The case law developed with regard to people that disappeared during the deprivation of liberty, and that's a huge difference, an important difference with regard to secret migrant detention, as alleged by NGOs. And here the one exception are extraordinary rendition cases, but evidence in those cases are very different than in the regular enforced disappearance cases. However, there are also other enforced disappearance cases where the person is disappeared by the Human Rights Committee and other bodies as well. So I believe that the case law can be raised in similar circumstances, but these differences have to be highlighted. And to me, two main open questions that are left is firstly, how will the court deal with the length of the deprivation of liberty when it's very short? What will that mean kind of for applying also the case law that has been established? And what about the less evidence or non-asking for the disappeared person in the migration context? So thank you.
Thank you very much, Grażyna, for this very inspiring talk.